Hi, my name is Carolyn Strnad. I'm a Family Resource Coordinator for the Minnesota organization on fetal alcohol and the mother of 3 children with FAS. In this video clip, I will be discussing how to address disagreements through informal and formal processes available to IEP teams. On our journey with our children with fetal alcohol spectrum disorder, we deal with individuals who acknowledge and support our goals and visions for our children and what is needed to achieve them, and with individuals who do not. Regardless of whether or not that partnership is one based on mutual respect and trust, no working relationship is without its bumps in the road. If the disagreement is one that does not impede progress being made in providing for your child's needs, you and others most likely involved can most likely agree to disagree and move forward from there. 100% agreement is great, but not always possible in a situation. Some things to consider when you feel that you have reached an impasse with your IEP team. Did you hear the other person's points on why the issue should be addressed his or her way? If you aren't sure, check for clarification. Did the other person understand what you are trying to tell them? Have they heard and understood your point of view? Is what you are asking the individual to do against the rules? And finally, does this disagreement change how or what services your child receives? If it does, then it cannot be ignored and you need to move forward towards developing a resolution. Moving towards resolution of an issue can take many paths, from formal to informal conversations to facilitated IEP meetings or mediation. Whenever possible, start with the least restrictive process and moving up from there. An informal problem-solving strategy could include a phone call to the teacher or case manager, a meeting with the staff providing the service, email or written communication, or a request for an IEP team meeting. These methods can be used at any time a disagreement or concern arises on your part or the part of the school. Remember, it is okay to disagree with someone, but it is in the best interest of your child to stay calm. Arguments shut down the line of communication, and you may need to work with that individual or team that you have a disagreement with for the year or even for the total years that your child will be at that school. A more formal process is used for issues such as needs not addressed within the IEP document, team meetings that are confrontational or unproductive because of continued disagreements, a breakdown in communication and/or trust, and in situations where an outside perspective is needed for resolution. For example, you've had your child's annual IEP meeting. You agree with some of what was placed on the plan, but other items you are not in agreement with. Take the IEP home to review it. We do not recommend that you sign the IEP at the meeting. You have 14 calendar days to sign the IEP. If you do not agree with the plan, you still need to sign it. Do not ignore it. Or after the 14 days, it will simply go into effect as written. Check the I do not agree box, sign and date it, and return it to school. Once school receives it, they will move forward with setting up a conciliation conference. Don't let that formal wording throw you. A conciliation conference is set up when the school and parents and guardians cannot agree on the services, accommodations, eligibility, or service placement for the child. The meeting is much like an IEP meeting with the addition of the special education director for your district or a person designated as a representative from that office. Typically, the flow of the meeting begins with introductions, a statement of the purpose of the meeting, and time for you to share what areas within the IEP that you are in disagreement with. The school in response may ask questions and/or provide input on what their position is on that particular area of disagreement. The goal of the process is to come to some resolution regarding the area or areas of disagreement. Prepare for the meeting by reading through the IEP, listing your concerns and your solutions to the issue. Do not sign the revised IEP at the meeting. Take it home to review. If you agree with the changes, sign the document noting your disagreement by checking the appropriate box and return the signature page to the school. If you are not in agreement, sign the document noting your disagreement by checking the appropriate box and return it to the school within the 14 calendar days. If you do not come to an agreement, the process will move to the next step of mediation or a facilitated IEP. A facilitated IEP is a process where a neutral facilitator is provided who addresses communication issues and assists in developing an IEP that all parties can agree on. They are not there to address dispute issues. A facilitator is not there to make decisions. Both the school and the parents need to agree to facilitated IEP meeting. A form which is available through your district or on the Minnesota Department of Education website requesting the process must be completed and signed by both parties. The meeting held at school at an agreeable time with both parties most likely will last longer than a regular IEP meeting. To prepare for the meeting, you should write down your areas of concern along with solutions, much like you needed to do for the conciliation meeting. Mediation is a voluntary process in which both groups work with a third party who is outside of the school system to help clarify important issues and each other's perspectives. Mediation is offered to parents when they disagree with an IEP as written, but it can be used at any time when the team cannot come to an agreement over educational issues. The Minnesota Department of Education has trained mediators available. You can choose to hire your own mediator or lawyer, but you would need to be responsible for those costs. Mediation works best if both parties understand what the disagreement is and are willing to work to resolve it. Because this process focuses on the needs of the child, it can take away the personal agenda issue that some teams deal with. If an agreement is reached, it needs to be put in writing and signed by both parties. A due process hearing is held if either the school or the parent request it. It is usually requested when the disagreement involves a decision on placement, eligibility, or services provided. In a due process hearing, a hearing officer is assigned to listen and review both parties' information. This is done in a formal court-like process held within 30 days of the notice of intent to due process hearing. The hearing officer then renders a decision which is binding, meaning both parties must follow it. This process is the most formal process available under dispute resolution, and it requires legal representation. If judgment is in favor of the parents, typically, but not always, the school district will be required to reimburse the parents for legal fees incurred. The Minnesota Disability Law Center may be able to assist with a due process hearing. Contact information for them is listed on our resource directory. In conclusion, disagreements will happen. First, try to resolve them by using informal methods, such as phone calls, emails, and additional IEP meetings. Be respectful in your disagreements. Remember that you have formal dispute resolutions that can be used if a disagreement cannot be resolved. Start with the least restrictive process, moving up to the next level if no resolution can be found. Be clear in your communication about what the disagreement is about and how you would like to see it resolved. Resolutions should reflect what is best for your child. Contact your local advocate at MOFAS, ARC, or the Minnesota Disability Law Center for additional help. For more information, check out the resource guide on the MOFAS website at www.mofas.org.